With House Bill 19, and that's Heather Marciones.
House Bill 19, the purpose of this bill is clarification. So Chapter 349 of 2019 established requirements within the real property article for an escrow agent to enter into a written agreement with a purchaser and seller of certain residential real estate when the escrow agent agrees to hold trust money in escrow for the transaction. This bill alters these definitions for clarification purposes and to reflect practice. There was no opposition for this bill.
Been a motion for favorable. It's been seconded. Just give everyone a second just to understand the vote. Senator Cassidy.
Maybe Senator Wettis knows better on this one. I'm somebody with real estate. The effective date's October 1, 2021. Is that going to allow sufficient opportunity? I mean, we're requiring, looks like people to change their, how they do these trust, information has to go in these residential deposits and escrow agents. And I'm not one of those. I just know if anybody has any feeling of whether the October 1, 2021 date is going to cause any major problems, or are we okay with that date? I'm fine with the bill. I just don't want to, surprise. And maybe if anybody has any thoughts on that, if not, I'm fine with that date. But
it seems to me between early April and October is enough time for people who are in real estate and undoubtedly receive alerts from the real estate organizations to get their forms straight.
Great. Bill passes unanimously. All right, Jamie, we're going to do House Bill 71. Sorry. All right, House Bill 71. 71.
So this is the cross-file for the Juvenile Services Education Board program. The Senate passed out its own version of this, which was Senate Bill 497. Earlier this session, over in the House, there were some amendments to 497. It made the board an independent unit within DJS and set out various requirements for the superintendent and the board itself, and it sounds like this is where they landed on for what worked with them for the amendments. So I guess is the.
So is this is the one that they've amended the Senate version?
They amended the Senate version. You have the unamended House version in front of you. So I guess. Would your motion be to conform to the, gotcha. Yeah. So it would be to conform to the Senate version as amended by the House.
So the Senate has Senator Sharkelly's version. They've amended it. We just conform this House bill to what they did to the Senate bill. All right, so we got it's seconded. All right, it's amended, but go ahead, Senator Jackson and then Senator.
Thank you, Mr. Chairman. Is this the same amendment that was submitted about a week or two ago regarding the ATF folks, AFT folks, the teachers? Is that the amendment we're talking about?
Sure, Senator. I don't know. Was that didn't come through your office, did it?
It's for the educators.
I'm not sure.
That's not the amendment you're speaking of.
Well, it's the amendment that the House put onto the Senate version. So I'm not sure what the backstory on that was. So I don't know if that was the genesis of this amendment.
We checked with the sponsor, she was fine.
No, I thought I'd sent something over to Sandy. Okay, all right, thanks.
So from what I heard the council say, so the main amendment to what we passed is that this board would be independent within DJS? So currently, it works as a part of DJS.
Right. So
And
let me,
did GJS chime in on that at all? I'm just, we have an independent state board, but they don't have to work with anybody. So, I mean, it's going to be important that this board is operating in close cooperation with DJS. And I hate to see two groups out there fight. I don't know. So it would have been nice if that's a pretty significant amendment, in my opinion, to say they're totally outside of DJS. They're an independent board, but yet they're going to have to work with DJS because these kids are not out running around. And did DJS have any input on this at all, in the House or anywhere?
check with them. I don't have that in front of me.
I mean, and I supported the bill. I still support the bill. I just am wondering what kind of information we had in the House that made this seem like a really good idea to just move it. I hope it wasn't just a knee-jerk reaction to say, well, let's just make them independent, because I see them as different in how they have to work as opposed to the state board, because these folks have to work with DJS. It's just vital that they're not, sniping at each other. Somebody's got to be able to say, we're part of the same group here. Otherwise, it seems like everybody suffers, but. Okay.
Thank you, Mr. Chair. Well, it says the board's an independent unit within the department, and the board consists of the following members. One of them is the secretary. So I don't know how independent we're really talking about here. Well, I'm actually looking at the third reader copy of the bill over in the House, which I assume is
Which
what
just
we've
sets up
got.
what the board is.
The third reader reprint shows what the House amendments were.
House Bill 497? Senate Bill 497.
Received a response from DJS. They indicated that they'd been in contact with the sponsor and that they were comfortable with the amendment.
They're comfortable with it?
Right.
Okay, I'm fine then. Thank you, Amy, appreciate that.
Move favorable.
All right, excellent. Thank you. All right, Senator Jackson.
My office indicates that we sent it over on last Tuesday. The amendment,
Also spoke with, or heard from DJS on that. The AFT amendment they're indicating was already incorporated previously. They said that DJS was more about the independent board piece. But their indication is that the AFT amendment that you mentioned, Senator, was already incorporated.
okay. All right, and I'm fine with that. It was forwarded to me because they didn't think it was clarified enough, and I know the sponsor was good with that, but.
Okay, I can double check against what you had sent over and what had been incorporated into the bill and see if there's a matchup there. I personally haven't done that at this point. I'm just sort of working on what they've told me about it.
No, I understand. I know the reason they sent it over, they said that it wasn't specific enough. But yeah, if you check that, I'm fine either way. So I know the sponsor he thought that it was incorporated, and this didn't hurt it one way or another. So ATF I keep saying ATF. I don't know why. AFT is fine. All right, thank you.
Passes unanimously, favorable amendment. Okay,
You want to concur on the House version?
yes.
So that is Senate Bill 497, so the motion would be to concur.
The motion to concur with Senate Bill 497, everyone's okay with that? All right, Josh, let's go on to House Bill 226.
House Bill 226 expressly authorizes Baltimore City to use any fines collected by the city as a result of violations from automated enforcement systems to be used to administer the systems, and requires any remaining funds to be used for public safety or transportation infrastructure improvements consistent with the purpose and goals of the state Complete Streets program and the city's Complete Streets program.
A question for Josh. I know this is a session where we seem to be breaking apart our speed camera law, but what is it right now? What is the statewide requirement for speed cameras and how they're used, and what is this saying, the difference?
So the only difference is that it's authorizing them to use it for the Complete Streets program. So currently it's, they can recover costs, and then they have to use it for public safety purposes beyond that.
What is the Complete Streets program?
It's a planning, it's a law that was passed by the city council, and it's kind of a planning, sort of a streetscape type plan that would make, it seeks to make all streets accessible and usable for all modes of travel, from cars to bikes to walking to persons with disabilities. Being able to traverse them, so to make it complete streets. It's pretty simple.
So we have I'm familiar with State Highway does streetscape, where they go up and they fix up your street, they build bike paths and all that. But so right now the law says for the state, you have to use them to pay for the fees, or I'm sorry, to pay for the actual devices, or for public safety, policing, right?
Correct.
'Cause the idea is, well, hey, this is taking away time where a police officer doesn't have to sit there with a camera, so we're going to use that money on public safety. And now we're taking it with this bill and saying, well, now you can take it and build bike paths, you can plant trees, and you can do all this other stuff. So it is a diversion, whereas once we pass this, next year not only are we going to have 15 bills where everybody wants a speed camera on their highway, because we've broken that part of the law, now we're going to break apart the law that says how you can use the fund. So while people may say this isn't a big deal, it is, because this will be the session that once we pass this, we've completely shattered the speed camera law that seek to restrict the use of speed cameras and seek to make sure that the use of the fines was to pay for the devices and for public safety. So we'll have said, no, you can put them on different highways because they'll be back next year with that. And then now we're going to say you can come in with 100 bills next year to what to use the fees for. So for that reason, I don't like it.
Thank you, Mr. Chairman. So Complete Streets is a program that we actually passed in 2018. So as the General Assembly passed it as a way to encourage the mitigation of the mitigation of traffic and transportation, and to promote a more walkable, bikeable, pedestrian safety system. And we didn't include any appropriation for it, and this is, I suppose, I haven't spoken to the sponsor, but I think this is one way of directing some funding to encouraging those goals of Complete Streets, which I think many of us supported as a safety issue. So I would support this bill as a way of advancing those Complete Streets goals, again, which is a way of getting people out of their cars, onto the streets, and into the community, which I think furthers our public safety goals as well.
Josh, do we have a delegation letter?
Second.
So, what are we doing? I'm sorry. Am I okay? So this bill has a really interesting provision that I've never seen in my 7 years here in the General Assembly or my many years practicing law, and that's on page 3 and line 25 and 26. And what we would be saying here is you can spend it consistent with a law that's under the control of the Baltimore City Council. So this says also consistent and the complete streets program under the Article 26, Section 460 of the Baltimore City Code. So we don't control that code. We don't amend that code. Baltimore City can amend that code to say anything it wants. So the intent of the original camera laws was that these monies will be very specifically going back into transportation and transportation safety, because we're ticketing people from all over the state. So it's a compact that we got that I'm not going to just run these cameras and ding you just so I can fund my general fund here. And then we'll just kind of put cameras everywhere, and I'll just eliminate local taxes, and I'll fund my jurisdiction on that. So to give this carte blanche and anything that you want under your own code, I think it's really a way too far. So I would just propose that we have it so complete streets program under 8903, the transportation article, period, and delete everything after that.
But it said support with amendment or amendments. Can you explain what the amendments do?
I don't think I've received these until now, so.
Better hold this.
We are going to hold it.
Can't vote it out if you just got amendments right now. Council hasn't even looked at it.
Does either senator from Baltimore City know what these amendments do, or what the conversation was in committee, in delegation? Senator Sidnor?
I vaguely remember a conversation that was talking about the use of the money. I can't get more specific than that. I'm sorry.
So let's do this. Let's hold this. We'll be back a couple times today, so we'll hold it. And once we understand what the amendments do and what the vote was in delegation, if the two senators from Baltimore City could just be ready to offer an explanation.
Okay.
Excellent. Okay. Let us go on to, can we go, Jamie, let's go to House Bill 477. I think, Senator Castle, you're the cross-file for this. Sorry, Jeff, did you want to speak on that?
No. I found it strange. It's on hold.
So House Bill 477 specifies the ways in which an application for a court order authorizing or directing a law enforcement officer to use a cell site simulator or obtain location information from an electronic device, which is authorized under existing statute, may be submitted to a judge. It also specifies the ways in which an applicant for a court order and a judge may converse about the application, and finally specifies the ways in which a judge may issue a court order pertaining to cell site simulators and obtaining location information. It is. And Senator Cassidy's the cross-file, which is Senate Bill 383.
I kept on asking.
Yeah, it's a good bill. All it does is let you use the same procedures that are currently used for search warrants and everything else to apply to these, so recognizing that people are in different locations, and but it's the same stuff, just let you talk by, video like we're doing with the public now, or by email, and not require you to walk into somebody's office 3 or 4 counties away.
Is everyone okay? The motion's for favorable, it's been seconded. Is everyone okay? All right, everyone's good. And then we'll move the Senate bill as well. Same vote for, what's the cross-file? Senate bill
383.
383. Is everyone okay moving that as well? All right, excellent. Let's go down to, Josh, I'm coming right back to you, 480. House Bill 480.
House Bill 480 prohibits stopping, standing, or parking a vehicle in a designated plug-in electric drive vehicle charging space unless that vehicle is a plug-in electric drive vehicle that is plugged into the charging equipment. The bill establishes requirements for signage for these charging spaces. A person who violates the bill's provision is subject to a civil penalty of $100. A parking facility that's privately owned or owned by a local government may have a vehicle towed or removed if it's in violation. Local governments may also ticket vehicles in violation. Any local law authorizing towing or removal from a facility owned by a local government must meet or exceed the standards set forth in the state towing laws.
Jamie? Just a real quick, so they deleted the sign, the 18 inches high, 12 inches wide, and clear and visible. I assume that's because there's other provision they added in which says has to be consistent with uniform traffic control devices, so that just replaces that, and that's what they follow, right?
That's correct.
Okay, that makes sense.
Thank you. My question's for council. When we passed the Senate version of this bill, did we keep in towing or did we exclude towing?
So the committee did not pass the bill. I remember it came up in discussion that there was an amendment to remove the towing part of the bill. The Senate bill, just to clarify, it was Senate Bill 315. It wasn't a cross-file because it wasn't exactly identical, but it was very similar.
Towing.
The committee did not pass that.
What do you want to do on the towing? It's a good. I'm glad we tanked that bill. I'm sorry, but Senator Castley, go ahead.
I thought it was just a ticket, a whopping ticket, and I'm just not into the whole towing thing. That hit the guy with a stiff ticket. I have no problem with that. That towing just gets ugly and nasty and expensive, and I think you can have the same impact with I don't care, a ticket.
Towing provision, Chris. Towing.
Thank you, Mr. Chair. When I moved favorable, I had not gotten far enough through the bill to see the towing part. I'm not wild about the towing either. Can't we just amend the bill to take out subsection D, the towing section? Let me ask you this. If a car is parked in a handicap space, doesn't have a handicap thing.
It's a question for council.
Do we permit the car to be towed, or is it just a citation?
I'm not sure.
It's just a citation. Well, this should just be a citation.
Yeah, do you have an amendment?
Yeah, I propose amending it by deleting subsection D on page 4.
D.
In my copy.
Page
of the bill,
4,
it's
line 6.
D. It's lines 6 through 17.
Yeah, in the third reader version, it's subsection D because the House struck what was subsection D. In the first reader version, it would have been subsection E.
Yeah. All right. Is everyone okay with that amendment? All right, great.
And with that, I move favorably on the bill.
All right. Senator Castley.
Section E, it's lines 18 through 22. It says that the plug-in electric vehicle charging space would reduce it counts as one of your spaces under the American with Disabilities Act. So, I mean, that makes sense if you put a charging station in a qualifying parking space, but if you say, well, currently I'm required to put in 3 handicap spaces, but I'll just put in, I'm not going to put those in, I'll put in 3 electric charging vehicle stations that are not handicap equipped, is how I read this. And so I can eliminate my handicap spaces and just put in electric vehicle charging spaces and call it a day. If what they're trying to say is, if I put one of these in a handicap space, that's okay. You can double up as both a handicap space and a charging space for handicapped people. But to say, well, and I'm not sure how that can be legal, because it's the American with Disabilities Act. And we're basically here changing that act and saying, well, we're going to call a charging vehicle station a handicap vehicle qualified parking space. And I don't know how we can amend the ADA with this bill, at least constitutionally.
The way I read it, it states that these spaces shall be counted as part of the overall number of parking spaces. So I'd have to double check the ADA, but I believe it's like a ratio. You have to have a certain amount of compliant spaces per overall spaces. So it's simply saying, you know, if you've got 5 of these electric spaces and 20 other spaces, your overall number of spaces is 25 for the purpose of having a sufficient ratio of handicap spaces.
Okay, all right, I'm fine with that reading then. Okay. All right, I read it different, yeah, a closer reading, you're right. I think Jamie's right.
Okay, as amended. Excellent. Sure, go ahead.
I have no problem with deleting the towing. Is there, oh, it's got the fine, never mind, the fine's still in there.
The $100
Okay,
fine.
I missed the fine.
Yeah. All right, so it's unanimous as amended with amendment. All right, let's go to 681. And Senator West, do you want to provide a little bit of explanation after council describes it?
I just put flags in my office. I was looking at the way that they hung those. That's all. Totally immaterial. Just carry on.
So this bill establishes a task force to study the Maryland Orphans Court. The task force must 1. Examine the composition and purpose of the Orphans Court. 2. Review and compare the Orphans Court to each local jurisdiction. 3. Analyze and compare the laws and practices of other states related to probate courts. 4. Examine any other research, analysis, or guidance related to the best practices of probate courts. And 5. Make recommendations on how to improve the Orphans Court.
Just really briefly, the fiscal note indicates that this study can be done at no cost, no additional cost to the state, so it's not going to be costly. In my own experience, the orphans courts are a mess, and they need to be studied. I'm not sure they've been studied in decades. It's about time we did this, so we should pass this bill.
Move favorable. But thank you for that explanation. I was thinking similar.
Geez, I wish we'd had this one earlier, because if we change it, it probably won't clear. But here, just for the record, that on line 21 on the second page, 5, it says make recommendations to improve the Orphans Court. It really should have said improve or restructure, because quite frankly, the way the Orphans Court work right now is like in my county, we don't have a separate Orphans Court. The Circuit Court deals with the orphans. They sit as the Orphans Court, and it's a much better structure as opposed to other counties where you go in and you have like a 3-judge panel of lawyers, and sometimes it can get really ugly because they are elected, not appointed, and whoever gets elected is in the Orphans Court, and these are serious cases sometimes. They deal with big dollars on people's estates. It would have been ideal to me if they could have looked at restructuring and possibly just eliminating the Orphans Courts, and I just feel it's sort of regrettable that it's only recommendations to improve the existing system, and I think we ought to be looking at or restructuring the existing system. So that's
thing, believe it or not. So both Senator West and Senator Castley have articulated my thoughts, but I guess that my interpretation was that a conclusion that is possible is that we need to eliminate them altogether. Do you not think they can conclude that with the language we have here? Like,
improvement,
have
you
them
take what you
absorbed
got
within the
and-
circuit court. And
Yeah.
I'm not even saying I favor that, but I'd like
Yeah.
to see what the data shows.
I mean, if you say improve, you're like, take that line of cars and improve it versus saying, those are clunkers, stop, don't do them anymore, do a different line of cars. And if I'm on the committee and you're saying, well, that's not really what, we weren't tasked to restructure it. We were tasked to come up with improvements. How do we, put lipstick on this pig? So anyway, thank you.
I don't know why in the world the existing language won't permit the task force to issue an alternate recommendation that the orphans court be abolished if they've come to that conclusion. I would not want to amend this at this point.
I agree with Senator West. If we could amend it, if we had time, but we don't, so we'll go with it and hope that they see them, interpret their jurisdiction very, very broadly. Thank you.
The motion is for favorable. It's been seconded. Is everyone okay? All right. Excellent. All right, let's go on to, this is Jamie, this House Bill 180. That was ominous.
So House Bill 180 establishes special procedures for juveniles who commit certain offenses involving or arising out of sexting. Specifically, the bill establishes that a juvenile court proceeding, or in a juvenile court proceeding, for violations of specified obscenity and child pornography laws, it is a mitigating factor that a violation involved or arose out of sexting. The bill prohibits the juvenile court from making certain dispositions for these violations, except under certain circumstances, authorizes the juvenile court to order a child to participate in an educational program on the risks and consequences of sexting, and establishes that a child who violates a provision of Title 11, Subtitle 2 of the criminal law article, which relates to obscene matter, is not subject to sex offender registration.
I appreciate the spirit of the bill, and I'll hear what other members have to say, of course, but, the thing that jumped out at me in hearing the explanation is that I don't know why we would wait until a child is under the jurisdiction of the juvenile. I don't know if we could amend it or how much leverage or leeway we have here, but I think it could use a little bit of work. At least that one thing is important.
Suggesting just have them have, good. What is your amendment?
Just that there would be education prior to a child being under
Sure.
jurisdiction of the juvenile system. We want to be a provision where there's some mechanism of education, and I know that changes the character of the bill because this is about juvenile and not about education. But I can't hear you.
Can't they do that under current law? Can't they do an informal adjustment?
I hear you, but that's not exactly the same thing. I mean, my whole thing is, why are we going to penalize children for doing behavior that is often stuff children do, and we haven't let them know ahead of time this is not a good thing to do? But I know what you're
I
saying.
agree with you 100%. I'm with you. I think under current law, they might be able to do this.
I know. I get
Okay.
you. Just, at that point, they've been booked. They've been handcuffed out of the school, taken to baby bookings or whatever, and then they come to the conclusion.
Yeah, I think this is a very important bill. I'd like to just move it. I understand what you're saying, Senator Carter. I think we have to be proactive to let these kids know that this isn't appropriate, but maybe that's the subject of another bill, or as Senator Wallstreicher said, it may be covered already. I would just like to move the bill now.
I want to be clear, it's not covered already, but I
But
won't
maybe we could
stand in
do
the way if
another
that's the will
bill.
of the committee.
I agree with you. I think they need to know. Thank you. I'd like to move the bill, though, favorably.
Thank you. A couple of questions first, before we rush this. So on page 3, it says that it doesn't apply, it's not sexting if the recipient, that would be the person, I guess, who got the sex picture as a recipient, right, is more than 4 years older than the sender. Is there a logic to that if the recipient is more than 4 years older than the sender, that's not sexting? Why would we limit this bill to?
I think the idea was to align it with provisions in the sex crime statute where the age gap between the offender and the victim exceeding 4 years would make it a sex offense. I remember Scott Schellenberger bringing this up during the bill hearing as well, and I think that how this ended up, or what ended up being decided is that when if it fell outside of that 4-year age gap, then it wouldn't be sexting, so it would just be a regular violation of the obscenity statute. So it wouldn't qualify as sexting and qualify for the mitigation.
So, okay, so it'd be okay if a 13, 14, 15, 16, so a 17-year-old's getting pictures of a 13-year-old girl. That would not be sexting, right? I mean, a 17-year-old who encourages a 13-year-old girl to
because
send nude
there's
pictures
more
of
than
herself.
a 4-year age gap there.
Yeah, that wouldn't be
right.
That would be okay under this bill.
Okay. Not okay. It would just qualify. You wouldn't qualify that one with the mitigating factor that that's present for sexting.
Wait,
so that would just be a.
Wait, this says it does not include, sexting does not include conduct if. So it's not just mitigating, it's not sexting.
Right, so it's not sexting, therefore it can't be mitigating.
Right.
So, right, it would have to be, sender is more than 4 years. Right, so if they're more than 4 years older, then it wouldn't be mitigating, it would just be the regular violation of the obscenity statute.
So what happens when the 14-year-old or the 13-year-old sends them to a 17-year-old, and the 17-year-old sends them to a 25-year-old? Has a crime of sexting taken place then?
Sender is more than 4 years old. Well, I don't, I'm looking for the provision. I know previous iterations of this have had contemplated whether it was sent to a third party or not, and I'm not seeing that with this one.
Okay, so you could kind of wash the picture by, if you're going to do it, have the 13-year-old send it to a 17-year-old before you send it to the 26-year-old. So you can kind of wash the. It's just like laundering money. We're going to launder dirty pictures.
Does not include conduct described in paragraph 1. So it would be, I think in, let's see, A23, Senator, that might cover it because I think under your scenario, it's not consented to by the victim.
I mean, I don't 100% know the answer to that, but it seems to me we're trying to make a distinction about kids, teenagers who are in relationships doing this with one another, that we don't want to criminalize this teenage behavior. No comment on whether it is appropriate or not. It's just, it is what they're doing, as distinct from people who are getting pornography who are older. And so we're not changing anything there, but we're just trying to decriminalize what is happening among teenagers right now and keeping that, or using it as a mitigating consideration in the course of this kind of violation. But I don't think we're in any way excusing or lessening penalties for older people. So under your scenario, we're not changing the law with regard to the older person having received that piece of pornography. So I don't think it's fair to say we're washing it, or, allowing this process to launder.
Right. I think Senator Hedelman hit it right there, which is that the 26-year-old in your scenario would be charged with possession of child pornography. This would apply in a juvenile court proceeding. So it would be that, I guess, 15-year-old and that 17-year-old that were involved in the juvenile court proceeding, but not in your scenario the 26-year-old who received it as a third party.
Please, thank you. I have the floor. Thank you, Senator Castley. I think you answered the question, Counsel. I think that the older guy would get charged and prosecuted under our current child pornography laws. Is that correct? Just as you clarified, right?
Right.
The older guy. Okay, thank you.
Yeah, so tell me this, could if in juvenile court, if a 16-year-old or 12-year-old provides a 13-year-old with cigarettes or alcohol, would that be delinquent conduct and they could pursue them in the juvenile court?
Charged.
I mean, it would be a delinquent act, right? If I'm if a 12 years going around and he's distributing cigarettes or alcohol.
Yeah, but I guess something like that would be like contributing to the delinquency of a minor, and I'm trying to think of situations where a minor is actually charged with contributing to the delinquency of another minor.
Well, I mean, it's at least when I was growing up, it was pretty common for people to hand, some guys would somehow get packs of cigarettes, and then they would be suppliers of the other 12-year-old boys, so we'd be saying, but that's potentially a delinquent act. But if they would just gotten pictures of their sisters and nude pictures of their sisters, that would be okay. I'm finding a really tough time dealing with this one, because somehow to suggest in here that sending nude pictures of a minor, even though to another minor, is somehow, that's just normal sex. I think that's outrageous. That's horrible behavior to in any way condone. And why should we keep that out of the juvenile courts? To say, well, as long as everybody's under 18 here, and we got 13-year-old girls sending nude pictures to 17-year-old boys, or 17-year-old men, for God's sake. Those are young men, not even boys. That somehow that wouldn't be a delinquent act, and them encouraging that. I find that much more harmful than trading cigarettes or beer stolen from your daddy's refrigerator or something. I'm not following the logic of this bill at all.
So when we passed this was a mess, and for exactly this reason. And actually, this bill just makes it a mitigating fact, correct? When we passed it, I had grave concerns that we were going to criminalize teenagers just doing stupid things. And some things, quite frankly, should be dealt with the household. And the parents and families and others should take care of it and not throw it off on the state. And 15-year-olds, 16-year-olds are going to do stupid things. Doesn't say it's okay, doesn't say it's allowable, this doesn't say it, but it at least says it's mitigating. Right now under the law, a 16-year-old boy or girl sends a picture to their boyfriend or girlfriend they shouldn't have, they're going to become criminal like sex offenders. You treat them like sex offenders. This law was completely problematic, and I tried to put a Romeo and Juliet exception into it when we passed it, knowing that this was going to happen, that we're going to have these cases, and so I would move favorable on this.
So, Senator Castley, when we looked at that N-Ray SK case, this was a case where a juvenile sent a picture of herself engaged in a sexual activity. I mean, and to criminalize anything like that, I think is ridiculous. So I think this bill moves us in the right direction, and I agree with Senator Huff.
It's been seconded. We're going to roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castle.
No.
Senator Huddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes.
Bill passes favorable.
Okay.
On the bill that I'm the floor leader on the signs, Delegate Perez bill.
I'll find out on the fiscal note first. Oh, wait, go ahead.
Chairman Gazzoni signed off on the bill moving forward, so.
So both of these bills were Senator Waldstreicher's bill. They were the ones who altered that had a constitutional amendment that increased it to $30,000. So this instead of $30,000, it's $25,000.
All right. $5,000, hardcore. All right.
They showed you, Jeff. Your bill as it came in, I heard what they said about it, but that 5,000 makes
They really knocked it around. All right. So the motion is to concur, vote for both. Is everyone okay? Recording. Okay, got it. Got it.
Everybody's good?
Yeah.
All right, so the next one, SB 726 is Josh.
As passed by the Senate, SB 726 authorizes a personal delivery device to operate without registration on a roadway, sidewalk, or crosswalk in the state. It establishes standards and requirements for those devices and provides that on or before October 1st, the MVA has developed a process for permitting the use of such devices until the bill's authorization comes into effect in July of 2022. The House amendments authorize the devices to operate on shoulders. It clarifies the provisions of the bill regarding insurance coverage. It requires these devices to obey all applicable local laws and clarifies that the process the MVA engages in is a pilot program.
Motion's concur. Okay, everyone's okay with that. Great. Part of that amendment was for the to adjust for the amendment that was added on the floor by our colleague from Montgomery County.
SB 832 is Southern Maryland multifamily dwelling registration fees and fines. SB 832.
Who's counsel for that?
Heather. SB 832.
To concur or not concur?
Oh. Concur to do, to match it up to what the Senate did. So I recommend concurring, so that way this bill will mirror the bill that JPR passed. So that's what the House did. The House mirrored our amendment, so that now we're accepting it. Accountability Employee Assistance Program, SB 74.
I want to let people go.
Dealing with employee assistance programs and early intervention programs. The House amendments strip out the bill.
We're going to pull on. All right, we're going to come back. We'll come back out to the floor to vote again. So let's take a pause for now.